Hello, this is Sarah Braasch. Welcome back to my channel. So I wanted to do a video about hate crime legislation and why it's unconstitutional and just really stupid. And this was important to me. Obviously, it's a very important topic, no matter what. But it was really important to me to do a video about this because one of the reasons why I was vilified and defamed on a global scale as a genocidal villain by woke intersectional feminists and social justice warriors at Yale and everywhere is because I am opposed to hate crime legislation. I've been opposed to hate crime legislation basically for forever. And it was actually, I voiced my opposition to hate crime legislation as grossly unconstitutional a decade ago and even longer, But in particular, a decade ago when I wrote a number of essays, when I was a fairly popular essayist in the online atheist secular humanist world, and I wrote a number of essays about my opposition to hate crime legislation, and I have for a very long time considered my sort of catchphrase to be I love hate speech and pornography. Don't forget about pornography. And I hate crime legislation. So I wrote in these essays about my principled opposition to hate crime legislation as grossly unconstitutional based upon the US Constitution. And that was one of the reasons why, in particular, the American Humanist Association and Jennifer Barty, the editor of the Humanist magazine, censored my essays, including the ones that described my opposition to hate crime legislation as racist and as too taboo and dangerous for free thinkers to read for themselves, so that they could realize for themselves that there was absolutely nothing racist about those anti-oppression essays that I wrote a decade ago, which they loved and lauded. So that was fun and a surprise. But I don't think I fully, even after what I experienced in spring 2015 at Yale, when I was socially ousted from the Yale philosophy department by most of the other graduate students as an anti-LGBTQ bigot because I had stood up for the federal civil rights of an evangelical black man at Yale. Even after that experience, I don't think, because I really isolated myself after that experience, and I was still protected by my advisors and mentors on the faculty at Yale, in the philosophy department and in the law school, and in the psychology department as well. I didn't fully understand the way that the woke intersectional feminists and social justice warriors had usurped academia. I didn't understand. I didn't fully appreciate it. So when I was being interrogated by the Yale administration after the Living or Napping While Black hate crime hoax at Yale in May 2018, I was shocked. I thought, are you Maoists now? Are you Maoists now? That you're interrogating me about my principled philosophical and legal position, which is a perfectly respectable position to take, which in fact is the right position in my opinion. Maybe not so humble, but it did come as a shock to me, and it came as a real shock to me when I found myself being the target of a cottage industry to destroy my lifelong human and civil rights, academic and legal careers by the atheist and secular humanist organizations that a decade prior had lauded me and had loved me and had loved my essays. my anti-oppression essays. So that was fun. That came as a nice little surprise too. I just was completely flabbergasted and just in a state of absolute shock. In fact, for most of the month of May 2018, I would literally go into convulsions and chills because I would literally go into physical shock pretty much on the hour, every hour when I was conscious. So that was fun. But what I want to talk about now, and yeah, I'm not a Nazi. I would like to let all of the public figures on Twitter with blue check marks and millions of followers know that no, I'm actually not a Nazi. I'm actually a lifelong human and civil rights activist, and I have a very principled, I'm also a constitutional law scholar, and a First Amendment attorney, a licensed First Amendment attorney. And I actually, yeah, have a very principled opposition to hate crime legislation. And the reason why we have hate crime legislation is because the people who pushed it through and promulgated it made anyone who even dared to express any doubts about its constitutionality feel like they are evil and bad people. And I just want to let you know that I am a lifelong human and civil rights activist, and I have a very principled opposition to hate crime legislation as grossly unconstitutional. And you are not a bad person if you oppose hate crime legislation. It is grossly unconstitutional. And I believe that hate crime legislation is one of those things in future decades, once we have recovered from this moment of mass cultural insanity, we will realize is stupid, really, really stupid, and really unconstitutional. And those laws will be repealed. I absolutely believe that that will happen. And I'm going to do everything in my power to make that happen. And so I want to explain why hate crime legislation is really, really stupid and grossly unconstitutional. So first and foremost, hate crime legislation is grossly unconstitutional because it's a violation of the First Amendment. It is grossly unconstitutional thought and speech crime. Okay? And I want to explain why it is absolutely thought and speech crime. Okay, hate crime legislation is unconstitutional thought and speech crime because it criminalizes the motive. It criminalizes the motive, okay? Now, something that people often get really confused about, and I don't want this video to be too long, but I think I'll do a much longer blog post or series of blog posts about this. It's something that I've written about before. So, hate crime legislation criminalizes the motive. You cannot criminalize the motive. The motive is the why. So the first thing people will say when I say that you cannot, it's unconstitutional, it's thought and speech crime to criminalize the motive. People will say, oh, but we do criminalize the motive all the time because we have different degrees of murder that indicate your different mental states. If you have malice aforethought, that's going to be, first degree murder, etc., etc. So that's the first thing usually that people will say to me when I tell them that hate crime legislation is grossly unconstitutional thought and speech crime. And I say no, because mens rea is not motive. And it's very important to make a distinction between these two concepts. So what mens rea is, it's mental intent. Mental intent is not motive, okay? Mental intent just means that you actually intended to perpetrate whatever crime it is that you're alleged to have perpetrated. And that comes in degrees. So you can do something negligently, and it can even be a crime. There is a criminal degree of negligence. You can do something recklessly. You can do something which means you should have known but you didn't, that what you were doing was going to, kill someone. You can do something knowingly, like you knew that you were going to kill someone. Maybe you didn't have the purpose of killing them, but you knew if you did whatever you did, that was going to bring about someone's death or whatever the crime happens to be. That's the actus reus part, the act. And so then there's the two components of a crime, the mental intent and the actus reus, which is the action. Okay, and you have to have both. The mental intent does come in degrees, but you have to have both elements in order to say that someone has actually perpetrated this crime. And then the highest degree of mental intent is purposefully. And probably the first example that's used in law schools to explain mental intent, and probably the best example, is sleepwalking. Okay? So someone murders someone while they're sleepwalking. They have absolutely zero intent to murder someone, right? So we don't want to put someone in prison for life or give someone the death penalty if they murdered someone while they were sleepwalking and maybe they don't even remember having done it when they wake up, okay? So that's usually the first example that's used in law schools to explain mental intent. So mental intent has nothing to do with motive, okay? So the motive is the why. The motive is like, you killed someone because maybe you do hate black people. Maybe you hate black people and maybe you killed a black person because you hate black people. That's motive. That's the why you did it. Now, you could still have a conversation about what that person's mental intent was at the time that they murdered a black person or, killed a black person. So anyway, so that's the difference between mental intent and motive. Motive is the why, and that's why you cannot criminalize motive, because that's a violation of the First Amendment, because obviously motive is something that's inside your brain, and so you were criminalizing someone's thoughts, and we don't do that in the United States. And also, how do we know someone's thoughts? Oh, we know someone's thoughts because of the things that they've said, that they've been recorded as saying, the things that they've written. So that's why it's also speech crime. So that's why criminalizing motive is unconstitutional thought and speech crime. And hate crime legislation is the criminalization of motive. Now, at both the state and, I don't know if I want to make a blanket statement about states, because state legislation varies obviously from state to state. But there's also federal hate crime law, and then I think probably many states, maybe I want to go ahead and say most. I can look it up. But anyway, a lot of states have state hate crime legislation, maybe even most of them at this point. So anyway, the people who have promulgated these laws know that they're unconstitutional because they criminalize motive. They know this. How do I know that they know this? Because what they try to do is they try to say, oh, we're not criminalizing motive. We're not making motive an element of the crime. What we're doing is we're waiting until after the verdict in the sentencing portion. And then we're just allowing, typically what happens is that the judge can just impose a more, serious sentence upon the defendant who's been, convicted of the crime. And then in the sentencing portion, that's where they add on a stiffer penalty because it was a hate crime, deemed a hate crime. And so why is this a problem? Well, this is a problem because we have these things in our U.S. Constitution called fair trial protections. Like, you have the right to be tried by a jury of your peers, right? Like, they are the ones that sentence you for a crime. So not sentence you for a crime. I'm sorry, that they're the ones that determine your guilt or innocence, that they're the ones that, weigh in on in terms of the verdict. So what they're trying to do is get around this. So you are, and it's all, it's all playing funny games with semantics and the Constitution, and it's grossly unconstitutional. So you're being sentenced after having basically been condemned for having perpetrated a crime based on your motive, but you're not being given a trial with a jury of your peers. And then, and also it's grossly prejudicial because you're basically being said like you're just this, like, because a lot of evidence, even if it has a high probative value, will be inadmissible because it's deemed to be too prejudicial. Like it's just going to be so inflammatory and it's going to inflame the jury, and they're not going to be able to weigh the evidence objectively because they're going to be like, oh my goodness, this person is a monster. We have to convict them. And so that's another problem with hate crime legislation, because it's basically saying like, oh, this person is just this monster. They're horrible. They're this person who is a racist, is a bigot, is, homophobic, is sexist, is, whatever it is. And they're just this horrible monster. So of course, we have to lock them up and throw away the key. So it's also grossly prejudicial. So hate crime legislation is grossly unconstitutional thought and speech crime. It's a gross violation of fair trial protections in the U.S. Constitution. And moreover, it's merely morality legislation. Okay? And because it's merely morality legislation, it is a gross violation of substantive due process. So substantive due process is a doctrine of constitutional interpretation, which basically says, and the way I always tried to explain it in a really simple way that was easy to understand to my philosophy of law students at San Francisco State University, is I would say what that means is that, and Scalia had huge problems with the whole doctrine of substantive due process. And he also hates what I'm about to say. Oh, he's, rolling over in his grave over what I'm about to say. So anyway, so what that means basically is that the state has to have a decent reason to tell you what to do. The state cannot tell you what to do just because it feels like it. It has to have a real reason. Now, and the compelling nature of the reason that the state has to tell you what to do, to legislate what you may and may not do, depending on whether or not it infringes upon what is deemed a fundamental right in the U.S. Constitution, then the state has to have an even more important reason. And there are varying degrees of the types of reasons that the state have to have. And so if the state is infringing on your free speech rights, then the state has to have a compelling reason why it needs to do that. And so probably what's my favorite U.S. Supreme Court ruling is Lawrence v. Texas from 2003, which made anti-sodomy laws, state laws, unconstitutional and wiped them out. And so basically, and Scalia wrote a withering dissent to this ruling, but it's actually my favorite. So basically what the ruling says is that mere morality legislation, if the only reason for the existence of a law, state or federal, is morality, is to say you're a bad person if you do this thing, so we're going to have a law against it, then that is not even a rational reason for the state to legislate, to tell you what to do. And so hate crime legislation it's just the criminalization of motive, And that is merely morality. That is merely morality legislation. It's saying you're a bad person if you think these thoughts and speak these, statements. And so that is merely morality legislation, and it is a violation of substantive due process. It's tyranny. It's tyrannical because the state can't tell you what to do just because it feels like it. And all merely morality legislation is the state telling you what to do just because it feels like it. And so of course, there is a discussion to be had about this because, and it's something that I used to have in my philosophy of law class with my students, because what Scalia would say, of course, is that all legislation is morality legislation. And it is ludicrous to say that the citizenry, can't, well, especially when you're talking about, public referenda, like in California, which was a huge issue with the Prop 8 cases, which is something that I taught to my philosophy of law students as well. Then it's the citizenry acting as the legislative agent, the legislative arm of the state. But also, of course, the state legislatures and Congress, absolutely. Like, elected by the citizenry, of course. Like that, of course, they can promulgate morality legislation because all legislation is morality legislation. They can promulgate pretty much whatever they want. And it's ludicrous to say otherwise. That's basically Scalia's position. And there is something to be said for this point. It is not a ludicrous position. And so this is something that was really interesting in the context of, of the philosophical foundations of law that I talked about with my students, and then sort of the defining dialectic in legal philosophy, which is the Hart-Dworkin debate, which is really about, is our, morality and law separable? Are they necessarily separable? So that's a whole other issue. I won't get into that. But there is an argument to be made that the hate crime legislation is also grossly violative of substantive due process. And I take this position. So anyway, I think I'll save, this is getting a little bit long and I didn't want to make it too long. So I think I will talk specifically about how this affected me, the way that I was cited as the impetus for grossly unconstitutional hate crime legislation in state legislatures across the United States after the Living or Napping While Black hate crime hoax. That was fun. That was interesting. And I actually am, basically what was done to me is actually, I should in a weird way sort of thank them, because I'm now the perfect example of why hate crime legislation is grossly unconstitutional, and it's also just really, really, really stupid. So anyway, I think I'm going to wrap up there, but I hope you enjoyed this video. And I definitely will do more videos about hate crime legislation and also hate speech. It's something that people find really interesting, and that obviously I find very interesting. Oh, that's another important point, is that basically a lot of people in the US are under the misconception that that hate speech is not constitutionally protected, and it absolutely is constitutionally protected. In fact, hate speech is legally a meaningless term. But the reason why people don't think that hate speech is constitutionally protected in the United States is because we have hate crime legislation. I absolutely believe that. So people intuitively understand that hate crime legislation is unconstitutional thought and speech crime, but that's why they think, well, then hate speech can't be constitutionally protected because we have hate crime legislation. And it's no, actually, hate speech is constitutionally protected. It's just that hate crime legislation is grossly unconstitutional and needs to be, repealed everywhere it exists. But anyway, so I'll stop there, but thank you so much for everything. Thank you for listening, and I love you all so much for your support and kind words. They mean everything to me. And I will put my PayPal, me, and GoFundMe links below. If you would like to support me, please support me so that I can sue Yale and so that we can restore civil liberties, including free speech and due process on campuses across the U.S. and everywhere. Thank you so much. Okay, have a great night. Bye.